Ready, start. Circumstances, as is well known, from which an inference of guilt is sought to be drawn, are required to be cogently and firmly established. They have to be taken into consideration cumulatively. They must be able to conclude that within all human probability, the accused committed the crime. In the subsequent decision in Chattar Singh and another versus State of Haryana, this court warned against drawing hasty inferences from such evidence. It observed that the last seen theory is a weak kind of evidence. It would be unsafe to base conviction solely on this circumstance unless it is corroborated by some other strong and clinching material. Most recently, in Krishna Kumar and another versus State of Haryana, this court reiterated the dangers of indirect or presumptive application of the last seen theory, stating that the theory cannot be applied in the absence of clear and positive testimony, placing the deceased in the company of the accused at approximate time before the occurrence. The doctrine cannot be stressed to presume such presence indirectly, nor can conjectures substitute proof. As emphasized in Krishna Kumar within bracket supra bracket close, courts cannot presume the presence of the deceased with the accused indirectly or through conjecture. Here, to accept the last seen circumstance would require precisely such inference, stretching to vague and temporally separated sightings into a conclusion of guilt. The law does not permit such an approach. The last seen evidence in this case, therefore, fails to meet the threshold laid down by this court. It neither rules out alternative hypotheses nor completes the chain of circumstances and instead leaves wide gaps inconsistent with conviction. Thus, the prosecution's reliance on PW3 and PW4 falters on two counts. Firstly, the absence of TIP renders their identification unreliable, and secondly, even if their testimony is accepted, single inverted comma last seen, single inverted comma closed theory alone is insufficient to sustain the conviction in the circumstances of the present case. The High Court's reliance on PW3 and PW4 overlooks this cautionary principle. Beside the testimonies of prosecution witnesses, the High Court placed weight on the medical opinion of PW8 Dr. T.K. Pant, who conducted the post-mortem. He deposed that the cause of death was shock and hemorrhage due to an ante-mortem stab injury and suffocation by strangulation. He noted a deep stab wound in the throat consistent with a sharp-edged weapon, bluish ligature marks on the wrists, and multiple abrasions. He also observed injuries consistent with a blunt object inserted into the anus and opined that the stab wound could be caused by an axe but equally by a sword or knife, and the wrist marks were consistent with a rope. While his testimony confirms homicide, it does not link the injuries to any particular weapon or to the appellants. However, the manner in which the rope and axe were dealt with by the investigating agency and later by the courts below is deeply unsatisfactory. During the course of the hearing of the criminal appeal, the High Court itself observed that these material exhibits had not been properly examined.